Hello everyone, this is Preet Verma and this is the video of subject Legal Studies, Class 12th, Unit 6, that is Legal Services, and Chapter Meaning and Concept of Free Legal Aid and Legal Services. So as all of you know that the meaning of legal services is providing free legal aid to people, especially who are economically deprived and not in position to afford legal cost. So guys, in this video I will discuss the following topics under the heading of legal services. First, meaning of legal aid, then second, objectives of legal aid, third, historical background of legal aid, fourth, legal background of legal aid, and fifth, free legal aid under international law. So first is meaning of legal aid. So legal services or legal aid is the provision under which government or government agencies are duty bound to assistance to the people who are unable to afford legal representation and access to the court system. Legal aid is regarded as central in providing access to justice by ensuring equality before the law, the right to counsel, and the right to a fair trial. Legal aid essentially guarantees equal access to justice for all citizens who do not have sufficient financial means. John Rawls was an American moral and political philosopher, and according to his first principle of justice, each person should have an equal right to the system of equal basic liberties. Legal aid is to ensure that no one is debarred from legal advice and help because of lack of funds. Thus, the provision of legal aid to the poor is based on humanitarian consideration, and the main aim of these provisions is to help those who are socially and economically backward. Now, Reginald Heber Smith was an American lawyer and director of the Boston Legal Aid Society in his namely Justice and the Poor promoted for the first time the concept of free legal assistance for the poor. Smith basically challenged the legal profession to consider it an obligation to make sure that justice was accessible to all, without regard to the ability to poor of their only protection, but in places in the hands of their oppressors the most powerful and ruthless weapon even invented. As a result of Smith's book, the American Bar Association created the Special Committee on Legal Aid Work. Now the objectives of legal aid. So the major objectives of providing free legal services or legal aid are: first, to provide equal justice to all those people who actually cannot buy legal services for themselves. Second, to restrain rich people to take advantage of their richness in order to oppress poor class. To create a bridge between the poor and the rich in the society in order to provide equality to seek justice in the court of law. Now the historical background of legal aid. The provision of providing, though not distinctively but can be traced in ancient India as well as in many forms. However, at international level, it can be clearly observed in Hammurabi's history, as the king of Babylon announced his purpose in promulgating the code which he set up in the early years of the 20th century BC. That purpose was to establish justice on the earth to hold back the strong from oppressing the weak. Such social adjustment is also known as social engineering. So, social engineering may be defined as the science and art of making appropriate adjustments to human relationships as well as to promote the welfare of the community as a whole. In the savage struggle for existence, it is natural for the strong to take advantage of their strength. Of these adjustments, the most necessary as well as the most difficult is clearly indicated by the words of the wise autocrat of Babylonia. It is to prevent the strong from oppressing and exploiting the weak. The Code of Hammurabi, which had been written almost 4,000 years ago from now, had progressive law, as it was included the provisions of minimum wages, the right to be born a free man, and the need to work off your debt, and no incest. From the earlier times, there is evidence that lawmakers had sensed the disability of the poor. They had addressed that the disability must be taken into account in any sound scheme of social engineering. Thus, the Code of Hammurabi attempts to limit the charges made for the services to poor men, providing an instance wherein a surgeon can exact subjectively from the poor and the rich. Likewise, there were three processes whereby the developing civilization progressively moved towards social engineering through free legal aid. The first was to grant aid to vulnerable communities. The second was to put restrictions upon the exercise or privileges accorded by law to those well off. And the third was to strip those fortunate of their privileges and place the strong and weak on an equal footing before the law. But these three steps did not ultimately bring the society towards realizing its goal. There is one kind of weakness that is not adequately protected by restraints or by taking away the privileges from the fortunate. As law is not self-executing, the power of the society which gives sanction to law must be brought to bear upon the law breaker before a wrong done is made right. Mosaic law, that is law of Moses, gave to the poor man many privileges intending to aid him to escape from the bonds of debt and servitude. If the creditor took his poor debtor's cloak in pledge, he must return it by nightfall, for instance, otherwise he would have no covering for the night. So, prompt payment of wages to the poor was enjoined, for he was poor. According to Herodotus, justice in Egypt was administered without cost in order to give the greatest relief possible to those who were wronged. It is evident that court costs constitute the most obvious obstacle to the poor man seeking justice. Despite Herodotus' statement with respect to Egypt, it is probable that costs in some form have always been required of litigants. It may be that in early times, when the Hebrew courts sat by the city gate, there was free and easy access to all suitors. But the fierce charges of the sale of justice made by the prophets suggests the toll of heavy costs. Now the modern era. The civil legal assistance for poor people in the United States began in New York City in 1876 with the founding of the Legal Aid Society of New York. The legal aid movement caught on in urban areas. By 1965, virtually every major city had some kind of program. In UK, history of legal services can be traced back in 1944 when a committee under the chairmanship of Lord Rushcliffe was appointed to ascertain the facilities provided for giving legal advice and assistance to poor and neglected citizens in England and Wales. After extensive discussion, the committee proposed certain measures for providing legal advice to the poor and also to expedient the existing system whereby legal aid is available to persons. The committee submitted its report in 1945, and after being accepted by the British Parliament, the Legal Aid and Advice Act 1949 came into existence. Now in India, the Bombay Legal Aid Society proposed that a committee be set up to examine the question of legal aid to the poor. In 1949, under the chairmanship of late Justice N.H. Bhagwati, the Committee on Legal Aid and Legal Advice in Bombay was set up to consider the question of grant of legal aid to certain category of people. The committee submitted its report in October 1949. The same year, a committee under the chairmanship of Sir Arthur Trevor Harris, then the Chief Justice of Calcutta High Court, was constituted in West Bengal to examine this question, and the said committee also recommended legal aid to the poor litigants. Now the legal background of legal aid. As envisaged under Article 15 of the Constitution of India, the state shall not discriminate against any citizen on grounds of religion, race, caste, sex, place of birth, or any of them. Based on this cardinal principle, no citizen shall, on the grounds only of religion, race, caste, sex, place of birth, or any of them, be subject to any disability. Article 14 of the Constitution of India provides that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. On the other hand, an impartial independent judiciary is the guardian of the individual rights in a democratic society. In order for citizens to have faith in their court system, all people must access to the courts when necessary. Moreover, human rights and human dignity form the premises of social legal foundations of free legal aid. As part of the human rights, it is necessary to recognize the principle of equality and ensure access to justice. Now guys, about free legal aid under international law. In an international context, an explicit provision for legal services is incorporated in the International Covenant on Civil and Political Rights, that is ICCPR. Article 14, Clause 3, Subclause D of the International Covenant on Civil and Political Rights outlines the requirement for free legal assistance as follows. In the determination of any criminal charge against him, everyone shall be entitled to the following minimum guarantees in full equality: to be tried in his presence and to defend himself in person or through legal assistance of his own choosing, to be informed if he does not have legal assistance of this right, and to have legal assistance assigned to him in any case where the interests of justice require, and without payment by him in any such case if he does not have sufficient means to pay for it. Besides, there are a number of declarations and principles adopted by the UN which refer to effective legal remedy, of which free legal services in genuine cases form an essential component. For instance, Article 8 of the Universal Declaration on Human Rights, that is UDHR, provides that everyone has the right to an effective remedy by the competent national tribunals for acts violating the fundamental rights guaranteed by the Constitution or by the law. On the other hand, India has ratified the International Covenant on Civil and Political Rights, which came into force in 1976, and is bound by the international obligation to provide free legal assistance as per the requirements of the Covenant. The Supreme Court of India has adopted the method of giving effect to international legal obligations when these obligations exist in the Indian legal system expressly. The court also recognized international legal obligations as part of the law of land when Indian law can be harmoniously interpreted as in conformity with international law. So guys, that is all for today. See you in the next video. Bye bye.